Good afternoon. Good morning for some of you. This is Michael Munson. Welcome to today's webinar. We're delighted to have you here today, and we're going to spend the next 90 minutes talking about trans and non-binary employees in the workplace and looking at sexual harassment in particular. We'll spend some time today looking at the legal rights and options for trans and non-binary employees. We're really glad that you joined us today, and we're looking forward to sharing this space with you. Before we get started, I just wanted to let folks know that this webinar is focused specifically on workplace harassment as it pertains to sexual harassment in the workplace around trans and non-binary employees. If you happen to be a provider, we're glad that you're here, and I just wanted you to know that we won't be talking about Trans 101 issues, so if you'd like to have more information about Trans 101 topics, we encourage you to head to our website and check out some of the free resources that we have in terms of training on our website, or feel free to obviously check out any other website to get some increased information on Trans 101 issues. We have the next 90 minutes to share information with you on sexual harassment as they relate to trans folks, and then we'll have plenty of time at the end for some questions. Just a couple of housekeeping items first. We know that this content can be a little bit difficult for some people to listen to, and for some people it can be a lot difficult. So please take care of yourself in whatever ways that you need to do. Remember that this webinar is being recorded so that if you need to step away or if you need to take a break from listening, you'll have the option of going back and picking up where you left off if you'd like to. We'll have a couple of points today where we'll ask you some questions either through a poll or through an open chat, and we encourage you to participate, but again, please participate at your own level of comfort. You can download the PowerPoint slides now, as well as some other handouts in the little handout pod, which should be to the right of your screen if you have access to a screen or tablet. We encourage you to download those now, or you can feel free to download them from our website later. When we do launch a poll later, you'll see a screen that looks very much like one that's on the slide right now. It's very easy to select your answer when we put that poll up. We know that some of you are in listen-only mode and just are listening and rather than viewing this on a tablet or computer, so you won't easily be able to vote in those situations. We also know that some of you might be watching together in a group, so feel free to make a group answer when you vote. The other kind of interaction that we'll have today is through the question box, and the question box is key for a couple of reasons. We will have a chat question that we'll be asking you and to try to get some information and engage with you. But this is also the place where you can ask questions kind of on the back end if you're having some technical difficulties, if you'd like to ask a question that we can respond to later at the end of the webinar, this is the place to ask it. So on the screen, if you can see your screen, is kind of a highlight of what that question box looks like. So if folks are willing to right now, if you can find that question box, could you type in what state you're in? I know it might take a couple of seconds. Excellent. So some folks are from Minnesota and Texas and Wisconsin. We know that folks are from across the country, Pennsylvania, Georgia, Massachusetts. Excellent. Thanks for sharing where you're from. So it looks like most of you have been able to find the question area, so that's perfect. Again, that's the place where we'd like you to ask questions for Shelley to answer at the end of the webinar, as well as for asking any questions that you might have about technical issues. If we happen to miss your question, please feel free to ask it again. Sometimes questions do get lost in the process. We wanted to take a moment to thank the Time's Up Legal Defense Fund, who provided Forge with funding to produce this webinar, as well as some fact sheets on sexual harassment specific to trans and non-binary people. They also helped fund us to create a social media toolkit, which we're very excited to launch early next week. So you'll have access to that toolkit as soon as it goes up on the web. We're really grateful that the Time's Up Legal Defense Fund recognizes the importance of including a wide range of identities and experiences in the work that they fund, and we're proud to be part of their class of grantees. Today's webinar was developed by and will be presented by Shelly Gregory. Shelley is Forge's strategic project coordinator and one of the people on staff who knows a lot about policy and the law. I'll be turning things over to Shelley in just a moment. Once again, I wanted to introduce myself again. I'm Michael Munson, Forge's Executive Director, and I'm mostly your host for today to get us started and to help run things smoothly, hopefully smoothly. I'll add my voice in a couple of times with some quotes, but most of the time you'll be hearing Shelley's voice. Behind the scenes today is Lori Cook-Daniels, Forge's Policy and Program Director, and they will be answering your questions in that question box, like I just mentioned, and helping capture those questions that you have for Shelley to respond to at the end. Let me share with you very briefly a little bit about who Forge is, since I know that Forge is new to some of you. We are a trans organization that is 100% funded to focus on anti-violence issues related to trans and non-binary folks. We were founded in 1994, so this marks our 25th year. Several of our staff are in Milwaukee, Wisconsin, but the scope of our work is national. We devote about 75% of our time and energy to providing training and technical assistance to victim service providers around the country. With the remaining 25% of our time, we focus on providing direct victim services to trans and non-binary survivors and loved ones. Because we're national, the majority of our services that we provide to the trans community, as well as the provider community, is done through online social media, through our website, and through survivors' blogs and other electronic modes. We have two foundational principles that guide the work that we do. It guides all of our work. When we engage with both survivors and providers, our first goal is to approach this work through a trauma-informed lens. This sometimes is a difficult task since trauma-informed theory is constantly changing and evolving, but we try to stay up to date and be responsive to being trauma-informed. The second foundational principle, again, in how we work both with survivors and providers, is to focus on empowerment through highlighting resilience, building on existing knowledge, and promoting a sense of confidence in all that we have interactions with. One of the ways that you can keep up with new publications, newly recorded webinars, and upcoming events around the country is by following us on social media. We have an active presence on Facebook and Twitter and Instagram, and we encourage you to like us or follow us, and we will try to do the same with you. We have a couple of closed groups on social media that are geared towards survivors of sexual violence. So if you'd like to have more information about those kind of groups, feel free to reach out to us and we will share that information with you. If you happen to be live tweeting today, we live tweeted Tuesday's webinar. It was fun to do so. Please include our handle so that we can raise your voice as well. The hashtag that we were using on Tuesday and that you can use today is transsexual harassment. In addition to our main website, where we house the archived webinars and publications and many other resources, we wanted to draw your attention to the Trans Survivor blog. We're slowly populating this website, but many of you on today's webinar might appreciate the content of the healing tools and resources that we include on this blog. Our time today will cover a lot of territory. We'll share with you what sexual harassment is and what it's not. We'll look at a range of employee rights, when harassment is illegal, and what duties employers have. We'll also share with you employees' response to harassment and how people can protect their legal rights and take action if they choose to. We'll briefly look at what advocates can do and round out the webinar with some resources and then time for your questions. So at this point, I'm going to turn things over to Shelley, who's going to be your main host and facilitator for the rest of the webinar.
This is Shelly Gregory. Thank you, Michael, for the introduction and for hosting our session today. And thanks to all of you for your interest in this topic and for joining us for the presentation. As we proceed today, you may hear varying terms used when speaking about gender identity and gender expression. Both Forge and I honor the multiplicity of gender identities and expressions that are represented in workplaces and in society, and we acknowledge the diversity of language used by individuals During today's webinar, we will use the words transgender, trans, and non-binary in their broadest meanings and to include identities that lie outside of these often limiting terms. We offer this presentation today to help clarify the rights that transgender and non-binary employees have to work in an environment that is free of harassment. As you may know, the legal landscape regarding rights and protections for trans and non-binary individuals is ever shifting. We'll discuss federal law as it stands today. Note that you may have even more protection under any state and local anti-discrimination laws that may exist in the place where you live. We'll tell you how to find out whether there are laws like that where you live. And finally, the information that we share today is intended for trans and non-binary individuals to help employees identify illegal harassment in their workplaces and to make more informed choices about what actions to take. Please be aware that the information we provide today, as well as any of the resources available through our websites, for general informational purposes and are not intended to be legal advice. Right, so when we talk about harassment, there are two overarching principles that can't be overemphasized. First, harassment at work is never okay. It is never the fault of the employee being harassed if it does happen. It is never your fault when someone chooses to act out in harmful ways. Second, it is always your employer's job to keep your workplace safe and to keep it free of discrimination and harassment, which includes stopping it immediately if it does happen. Harassment can happen to anyone at work, including trans and non-binary employees. It occurs in all industries, in all professions, and it happens all over the country. The EEOC, which we'll talk about quite a bit today, and EEOC stands for Equal Employment Opportunity Commission. This is the agency that enforces our federal discrimination laws. The EEOC received 7,600, so almost 8,000 complaints of sexual harassment in 2018. And that was a 14% increase from the previous year. So workplace harassment, sexual harassment, we know is prevalent. If workplace harassment has happened to you or is happening to you, please know that you are not alone and that there's help and support available, including from Forge, which we'll discuss today. Workplace harassment is a form of employment discrimination that can happen to employees and to job applicants, including trans and non-binary people. Harassment is a type of employment discrimination. It is made illegal federally under the law referred to as Title VII. So that's Title VII, that means Part 7 of the Civil Rights Act of 1964. So Title VII prohibits discrimination. It prohibits discrimination, and this is a quote from the statute there, with respect to compensation, to terms, conditions, or privileges of employment. And terms, conditions, and privileges are a little bit vague, but really just mean, what are the conditions that you're working under? What are the terms that you agreed to with your employer? What are the benefits of your employment? Employers cannot discriminate in those areas. Workplace harassment, again, is a type of discrimination, and it's a different legal claim than what we consider typical employment discrimination. Now, discrimination claims generally challenge some kind of employer action that has negatively affected your salary or your benefits, something that directly negatively affects your paycheck, like being fired from your job, being demoted from your position, or having your pay cut for some other reason, or even not being hired for a job. Workplace harassment, on the other hand, generally refers to our work environment. We're referring to a work environment that is being made hostile or abusive for a reason that is illegal. And importantly, Harassment can be illegal whether your paycheck is negatively affected or not. Sexual harassment was first identified as a type of employment discrimination that is illegal under Title VII by the U.S. Supreme Court, and that happened in 1986. Harassment that happens to trans or to non-binary employees because of gender identity or gender expression is considered to be this kind of sexual harassment under Title VII. We'd like to share some information with you about what trans and non-binary folks are reporting as their experience in workplaces. Now, we know that trans and non-binary employees have traditionally experienced high levels of discrimination and harassment at work. In 2015, there was a survey of trans individuals called the U.S. Trans Survey. That survey included responses from nearly 28,000 trans and non-binary people. And that survey found that 30% of trans or non-binary employees experienced some form of discrimination in the prior year. 15% of respondents were harassed in some way in that prior year because of being transgender. And of those folks, 14% of them experienced verbal harassment, 1% of them experienced sexual assault at work. Nearly 23% of people who responded to the survey experienced one or more kinds of mistreatment at work in the prior year. Some of the top reported kinds of experience that mistreatment that people experienced are listed here. 6% received a poor review or a negative review, and they believe that was because of their status as trans. 4% of folks were told not to transition while at work in order to keep their job. 4% said they were not allowed to use a restroom that's consistent with their gender identity. Non-binary folks at work also have some unique challenges. The U.S. Trans Survey told us that 44%, so nearly half of non-binary people at work in the U.S. let the people around them make assumptions about what their gender identity is. They don't disclose their gender identity. And the top 2 reasons for doing that was because people don't understand non-binary identities, and that non-binary people find it easier just not to say anything about their identity at work. Now, in terms of actions that non-binary people have taken to avoid discrimination, respondents to the survey reported again that about half of them hide their gender identity at work. And then again, another half of them don't ask their employer or people at work to use pronouns or the name that they use. As more employers begin to acknowledge the identities of their non-binary employees, I think that we will see some pretty significant changes in workplaces. And we'll talk later about some of the challenges that non-binary people report at work and what some best practices are for employers. Now, one thing that's important to remember about sexual harassment is that all genders can be impacted by sexual harassment. Harassment doesn't happen only when the people involved have different genders. The gender of the harasser and the gender of the target of the harassment are really irrelevant. The Supreme Court told us that in 1997 in a case that was brought by a man who was very severely harassed by male coworkers on an oil rig. And that case went all the way to the Supreme Court because the lower courts didn't know at that time whether the harasser and the target of the harassment could have the same gender. And the Supreme Court said yes, absolutely. One other important aspect of harassment law to keep in mind is that harassment law does not require that the harasser is correct about the identity of their target. So if someone's being harassed at work and they are mistakenly thought to be trans or non-binary and that's why they're being harassed, that person still has the right to work without harassment, and they still have the protections of federal harassment laws. Another area that's important to sort of remember, and that I think a lot of people don't always recognize, is that witnesses who observe or hear or learn about harassment of another employee in the workplace have the right to complain to their employer and have action taken about that harassment. An employee does not have to be the target of sexual harassment in order to take action to protect their rights. So if someone in a workplace repeatedly makes derogatory or offensive comments about, say, trans people generally, or about even famous, well-known trans people like Chaz Bono or Caitlyn Jenner, or about a trans employee in that workplace, any employee who feels affected by any of that behavior, all of which is inappropriate, may make a complaint to their employer. It's not only the trans employee who has a right to complain.
Hey, this is Michael. I'm going to be reading a couple of quotes. The first quote today says, quote, "People need to be careful to not see harassment and discrimination as something that only affects the person targeted by it, and instead see it as affecting everyone. Mobilizing witnesses of harassment and discrimination represents an important step towards creating safer, more inclusive workplaces."
This is Shelley. Thank you, Michael. Yeah, so complaining about somebody else being targeted for harassment in a workplace can actually be a really wonderful form of bystander intervention, and it can often be a more effective way to get the harassment stopped than if the person who is the target does the complaining. We're going to shift a little bit now and talk about what rights trans and non-binary employees have under federal workplace sexual harassment laws. Now again, trans and non-binary employees have all of the same rights as other employees not to be harassed at work. Gender identity or gender expression or gender presentation are characteristics that harassment law says cannot be the basis for how we are treated at work. And we know that most people have a gender identity or otherwise identify as maybe having a fluid gender identity, or maybe no gender identity at all. However we identify, we are protected from harassment that happens because of whatever our identity is. Being trans or being non-binary, that is not what the law is protecting. It's not protecting that status. It's not protecting that particular identity. What the law protects is all employees, even those who aren't trans or who aren't non-binary, from having their gender identity, whatever it is, be used as a basis for their treatment at work. Harassment that happens because of gender identity or gender expression is considered sexual harassment. Sexual harassment includes these kinds of behaviors because it's sexual harassment when someone doesn't fit traditional gender stereotypes of masculinity or femininity. Not fitting those stereotypes and being harassed because of it is rooted in somebody else's belief in the workplace that, somebody is not being or acting how a man or a woman should be or act. And federal harassment laws have protected everybody from sexual harassment based on these kinds of gender stereotypes for a very long time. Again, the U.S. Supreme Court said that these kind of gender stereotypes are illegal. It's illegal to rely on them in workplaces, and they said that in 1986 in a case that we still use today in bringing claims for trans and non-binary people. And Michael will read a quote for us from that case.
Thanks, Shelley. So the quote says, Ann Hopkins was told that she needed to walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. She was called macho, told that she overcompensated for being a woman and should go to charm school. Shelley?
Yeah, this is Shelley. Thank you, Michael. So back in 1986, Ann Hopkins filed a lawsuit against Price Waterhouse, which is a large accounting firm, because she was eligible to become partner, and she did not become partner. She wasn't made partner by her male partners. Out of the hundreds of partners in the firm across the country, there were only 8 women partners at the time, back in the mid-80s. And so these are the things that Ann Hopkins was told were the reasons that she was not going to be promoted to partner at PricewaterhouseCoopers. And the Supreme Court rightly looked at that and said, no, you guys, and it was guys, can't have these ideas, have these antiquated notions of what femininity is, and you can't hold somebody to that in the workplace. So Ann Hopkins was not physically harmed. She wasn't asked for sex. She wasn't called names. But discriminating against her like this because she didn't meet the male partner's stereotyped expectations for her had an equally devastating effect on her career. And there's a way in which we all owe a debt of gratitude to Ann Hopkins, because as I said earlier, this is where a lot of the protection for trans and non-binary people from sexual harassment come from, even still today. Workplace harassment is a type of bullying. Targets of bullies are not responsible for the bully's actions. Similarly, workplace harassment, if it happens, is never, ever your fault. Harassment has no legitimate purpose, and it should never happen in a workplace. If your employer doesn't meet its legal duty to keep discrimination and harassment out of your workplace, or if they don't do it well, or if somebody at work just decides that they're going to act out and harass you, none of that is your fault. None of that is your responsibility. Like bullying, harassment at work can be really challenging to cope with, no matter what your job is. It can become distracting. It can interfere with your ability to do your job. It can start to affect your life outside of work. It can cause you stress. And it can bring up lots of feelings, including feelings of fear or shame. No one who is a target of harassment at work deserves this kind of treatment, and no one does anything to cause it to happen. You all have every right to be and to present yourself as you are at work. And again, there are sources of support for you that we'll discuss before we finish today. Again, with regard to non-binary employees have the same rights as all employees at work not to be harassed because of their gender identity. We don't have a lot of guidance yet from courts or from government agencies about how the law will evaluate sexual harassment claims that are made by non-binary employees. For now, you should know that trans advocates and trans lawyers are monitoring legal developments, they're bringing cases, and they're participating in discussions about how the law should work. And as I said, we'll return to non-binary employees a little bit later and talk about some of the specific challenges they identify at work. Learning more about sexual harassment in the workplace can help employees who are trans or non-binary do a few different things. First, it can help us recognize harassment on the job. Many people, whether trans or not trans, don't always recognize that abusive behavior that's happening at work is in fact illegal harassment. Learning more about our rights can help us respond to harassment. We have options to choose from in deciding whether to respond and how to respond. And learning more about our rights can help us decide whether to take legal action. the last thing that learning about our rights can help us do is can help us work with our employers if we'd like, to help prevent harassment if we have an approachable employer, or if we'd like to help them improve their existing efforts. And we've talked about what sexual harassment is and what rights trans and non-binary employees have. And now we're going to talk a little bit about the factors that can make harassing conduct illegal. It can be hard sometimes to know what behavior does and does not equal illegal harassment. And partly that's because courts and judges make the decisions about whether harassment at work will be considered illegal. Even if a judge ultimately says that harassment that's happening at work isn't illegal under the law, the harassment is always wrong and it still has no place at work. Now, one limitation that we'd like you to be aware of, and that's important, is that the federal law, Title VII, applies to employers who have 15 or more employees. So if an employer has 14 employees or fewer, the federal law will not apply to that workplace. And again, what we want to do then is look to see whether our state or the city or the county that we live in has non-discrimination laws that'll protect us. And we'll talk about that today as well before we finish up. Now, the law does apply to a broad range of employers and entities. It applies to private employers. It applies to employment agencies or temp agencies. It applies to unions and union membership. It applies to the federal government in its role as an employer. And it also applies to state and local governments in their roles as employers with some exceptions. Now, to be considered illegal, workplace harassment must be happening because of any of these individual characteristics listed here. These are the primary characteristics that federal non-discrimination law protects us from discrimination or harassment from. And so that's sex or gender, which again includes gender identity, gender expression or presentation. It includes sexual orientation. It includes pregnancy. There's race or color, religion, national origin or ethnicity, age if you're 40 and over, and disability or genetic information. None of those characteristics can be the reason that our employer makes any kind of decision about us or decides how to treat us in our workplace. A few notes about what workplace harassment is not. Although it's always wrong and it's always abusive, sexual harassment law doesn't always apply to all behaviors that can happen in the workplace. Some behavior may not be considered sexual harassment if a judge decides that it is what is called an offhand or an inadvertent comment or a single isolated incident of inappropriate behavior. However, workplace sexual harassment is a very broad protection. It is not limited only to behavior that is sexual in nature. That means it is not limited only to acts like sexual propositions or requests for sex or demands for sex or unwanted sexual touching or activity. Instead, it also includes treating others in your workplace in any kind of hostile, offensive, or intimidating way because of their sex, because of their gender identity, or because of their gender expression. Now, we have a poll that we'd like you all to respond to and we'll take a look at. Michael, could you bring that up for us, please?
You bet. So hopefully in a second you will see the poll, and the poll reads, workplace harassment laws protect employees from harassment by customers, student interns, delivery people, all of the above, or none of the above. So if you have access to a computer, phone, tablet, and can vote, we'd encourage you to click the radio button that is your answer. So workplace harassment laws protect employees from harassment by customers, student interns, delivery people, all of the above, or none of the above. And we'll just give it a second for folks to vote. And it looks like a lot of you have voted already, so I'm going to close and show the poll results.
Great. This is Shelley. Thank you, Michael. Yes, thank you, Michael. So looking at our responses here, it looks like the majority of you, almost 60%, think that sexual harassment law protects us from harassment from all of those categories of people. A fair number think that it doesn't protect us from any of those categories of people. And student interns got a bit of a vote there as well. Well, it turns out that the folks in the majority have the right answer here. Whoops. One second as I get us on the right slide. There we go. So federal harassment law actually protects us from harassers in any of these categories. It really protects us from harassment from nearly anybody who is present in our workplaces. So that includes managers, supervisors, employees that you supervise, coworkers, interns, board directors, and it includes clients and customers, and really it can include any person who is in your workplace and who can be controlled by your employer. If you experience harassment from a non-employee, so a third party in your workplace, like a client, a customer, a mail delivery person, the water bottle delivery person, the maintenance company that your employer contracts to come in and clean the office in the evenings. If you experience harassment from any people in those kinds of categories, you want to essentially respond to it in the same way that you would respond to harassment from an employee. You'll follow the same steps in responding to it and the same steps in complaining to your employer if that's what you choose to do. And we'll talk about those steps in just a moment. And the key issue with non-employees like these delivery people or maintenance staff from another company, the key issue is really how much control can the employer exercise over that person. The more frequently someone visits your workplace, if your employer has a contractual relationship with them, factors like that are going to make it much more likely that your employer really is able to exercise some control, to take some steps to make that harassment stop. Now, sexual harassment, regardless of who the harasser is, must meet certain legal requirements to be considered illegal. And these are the primary requirements here. And first, the harassing conduct needs to be happening because of gender identity or expression and not for some other reason. Second, the conduct that is occurring really needs to be unwanted by the target or the recipient of the harassment. Third, there is evidence that will show that the work environment that you're working in is intimidating or hostile or abusive. And fourth, the conduct is interfering with the employee's work, either because it's a series of many incidents that repeat and build up over a period of time, or sometimes it can be a one-time incident, a one-time really extreme incident, okay? And as I said earlier, recall that harassment can be illegal whether or not you've experienced a negative effect on your paycheck. Now, some examples of some one-time kind of extreme incidents that on their own happening one time may suffice to bring a claim of sexual harassment. One example is physical violence occurring in the workplace, and that can include things like hitting, kicking, pushing, throwing items at someone. Another example is sexual violence, which can include sexual assault. It can include an inappropriate touching of breast or genital areas. Because these behaviors can be so violent and so harmful, courts and judges have decided that, something like this happening even one time is sufficient to give somebody a valid harassment claim. Now, judges and courts will vary in their assessments of what behavior is illegal. Federal court decisions across the country differ on some of these issues. And believe it or not, sometimes they differ on issues like how long or for what period of time does somebody have to be touching someone inappropriately in order for there to be a valid harassment claim. And the important thing to remember is that there is a difference between behavior that is wrong and conduct that is considered illegal. And even if harassment you experience is found not to violate the law, this conduct is, again, never, ever, ever acceptable in your workplace. I'd like to give you some examples of some incidents that can repeat and build over a period of time and can altogether affect the workplace that you're working in, affect your working environment, and give you a basis for a sexual harassment claim. So some examples of these incidents are things like repeated failures to use somebody's correct name and pronouns, repeated failures to respect someone's gender identity or gender expression, failure or refusal to provide access to a restroom that is appropriate for someone's gender identity, forcing an employee to use a single stall restroom or an inconveniently located restroom, requiring dress codes or grooming standards. And grooming standards are things like how long your hair can be, whether or not employees can have facial hair, what your nails should look like, whether you can wear makeup, whether you can wear jewelry, whether you're required to wear makeup or jewelry. So requiring compliance with a dress code or a grooming standard that doesn't align with someone's gender identity is also not acceptable. Slurs, taunts, calling names, playing offensive jokes or pranks on someone, these can all be behaviors that can constitute illegal sex harassment. Some more examples are offensive comments that are made, images, so photographs, drawings that get shown to someone, written messages that are offensive. Those can be emails, those can be written notes, that can be writing on the bathroom wall. Shunning somebody, which is a really extreme form of ignoring someone or refusing to work with someone, could constitute harassment. So could following an employee around in the workspace or staring at them excessively, interfering with, messing with somebody's workspace, their desk or their locker or their lunchbox. Things like that can all give rise to sexual harassment claims, and so can many other offensive, hostile, intimidating behaviors. There's a few issues that non-binary employees have reported in surveys as causing some of their biggest challenges around their gender identity at work. Some of the commonly reported challenges that non-binary employees talk about are particular trouble in accessing restrooms and other facilities that are segregated by sex. Using forms, so employers' forms or employers' systems that only have binary options. Being addressed with correct pronouns, and honorifics. And honorific is like the examples there: Mix, Mr., Ms., Mrs. Gendered dress codes and grooming standards, again, can be a place that's really difficult for non-binary employees to figure out how to deal with in the workplace. And again, we don't have a lot of legal guidance yet about how the law is going to apply to non-binary employees, but I will say that what I am observing in human resources circles and in discussions around human resource issues and non-binary employees is that employer best practices really are going to have to mean that we eliminate all binary distinctions in our workplaces. So that means giving people more than two options on a form or in a computer system. You know, that means taking down those sex-segregated restroom signs or locker room signs and making all gender facilities available to people. We've talked a bit about employers' duties several times, and let's look a little more closely at what your employer's main duties are. Again, it's always your employer's job to provide that safe work environment free of discrimination and free of harassment. Well, what does that mean? It really means that your employer has two significant duties. One, they need to take steps to prevent harassment from happening in the workplace. And two, they need to take steps to remedy or to stop harassment if and when it does occur. Now, the steps that employers should be taking to prevent harassment in their workplace are summarized here on this slide. Employers should have written policies that explain and prohibit discrimination and harassment. They should have policies that explain what the complaint procedure is, what the investigation procedures will be. That policy should explain that retaliating or taking a negative action against an employee for complaining is also prohibited. Employers should be providing trainings to employees about sexual harassment that include gender identity and gender expression, and those trainings should be interactive if possible. Employers should have separate trainings for their supervisors and their managers who have some extra duties under the laws. And importantly, employers really need to follow those written policies, and they need to enforce them when employees violate them. Now, the kind of steps that employers should be taking to remedy or to stop harassment and to keep it from happening in the future appear on this slide. So we're talking about things like receiving complaints from employees of harassment, investigating those complaints, initiating investigations if the employer becomes aware of harassment through some other means, completing investigations that are thorough and prompt. And they should be keeping a complaining employee's identity as confidential as possible, and they should be taking action if other employees disclose confidential information. Employers must also take steps like keeping the complaining employee updated about any investigation that's occurring, informing that employee of the outcome of any investigation, and taking immediate action to stop any harassment that is happening at once and to keep it from happening again. And employers can do things as simple as moving a harasser's workspace, changing their job duties, changing their schedules, and when appropriate, disciplining or firing them. Whatever action is taken to stop that harassment, though, should not be action that punishes the victim of the harassment or the target of the harassment. There are also actions that employers cannot take when investigating or resolving sexual harassment complaints. Employers may not take action that negatively affects an employee after that employee has asserted their right to work in a workplace free of harassment. So that means that an employer may not take action after an employee, for example, reports harassment at work, reports that they've witnessed harassment, an employee who participates in the employer's investigation, an employee who maybe goes outside the workplace and files a complaint or a lawsuit or participates in somebody else's complaint or lawsuit. Taking negative actions against an employee who has done any of those things can be retaliation. Some examples of retaliation can be things like being fired, being demoted, having your pay cut, having your hours cut back, being disciplined. Retaliation, importantly, can also include more harassment or even just continued harassment that the employer has not stopped. All of these actions, when they can be shown to be happening because of an employee's complaint or other action that asserts their rights, any of those negative actions that are taken in response to that are called retaliation, and retaliation is illegal. So we have a question now that we'd like to pose to all of you and have you respond. Michael, can you bring that up for us, please?
You bet. So what we'd like folks to do is find that question area that you typed in your state when we first started. And the question that we'd like you to respond to is, what are some specific actions that trans employees should take if they believe they are experiencing sexual harassment at work? So if you want to share your answers in that question box, I will read them off so we can all hear them. So again, what are some specific actions that trans employees should take if they believe they're experiencing sexual harassment at work? So I'm not seeing any responses yet. There we go. So some answers could be report to management or human resources, talk to a supervisor, talk to EEOC, document the incidents, report to supervisor, document everything, keep a log that includes the date and time, details of incidents, location and witnesses, find a sounding board outside of the workplace who can validate their experiences to combat gaslighting, talk to their supervisor, maybe in writing, report it to human resources, talk to a higher up about starting an investigation, all of that. Are there any other ideas that people have? I know sometimes these are hard questions to think of when we're kind of having a blank slate. What are some other specific actions that trans employees should take? That was a really good list. Shelley, would you like to share some of the things that we think folks should do?
Yeah, thank you, Michael. Well, and thanks all of you for answering that question. Those really are some excellent answers, and they are a preview of some of the things we'll talk about here. But yeah, reporting to management, reporting to HR, reporting to a supervisor, reporting to a higher up. I mean, that is exactly right, and that is the way to get your employer to take action. And we'll talk about how to go about doing those things in just a bit. And I really appreciate that somebody gave us a very comprehensive idea about how to document and create records of what's happening to us at work by writing all of that down and writing down as many of the specifics as we can remember, like dates and times and who was present and who said what. And I think I heard some suggestions about going outside the workplace. So talking to friends, talking to somebody who can help you think through the situation and help affirm for you that, you know, yes, there's something problematic going on in that workplace. I think that's a great idea. So here are some suggestions that we have for folks. Number one, and this may seem intuitive, but it is in fact important and legally significant. Number one, we want to not participate in the harassment. If an employee harasses their harasser back, there can be serious consequences for the person who was initially the victim, including, you know, discipline or losing your job. And again, harassment is illegal when it is unwanted. And there have been times in cases where judges in courts have misinterpreted somebody's participation in harassment as being a sign that that employee welcomed the harassment of them. In that vein, number 2 is that we want to tell the person to stop. We want to talk to this person and communicate to them that we don't want this behavior to be happening. Again, because harassment is considered illegal only when it is unwanted, it can be important to make clear this behavior is unwanted and it's unwelcome. And importantly, there are problems that really can be resolved in the workplace by talking them out. And so it is a good first step to try to communicate with that harasser. Now, there are various ways we can do this to make that experience more comfortable, and when we get to decide for ourselves what might make that comfortable. Maybe we feel okay talking to somebody in person. Maybe we'd like to talk to them in person, but we bring a coworker or a trusted friend with us to have that conversation. Maybe we talk over the phone, or maybe we don't do it. We do it in writing. We do it through email or an instant message, or we leave a note in their mailbox. Whatever we need to do to communicate to that person that this behavior is unwelcome, we should try to do. Number 3, write it all down. So we already had a good suggestion about how to do this. Have a notebook or a computer file at home. You go home at the end of the day and you write down any things that happened that you think are relevant to what you're experiencing. And again, the details like when it happened, who was there, what they said. As many of those details as you can capture is great, because we think that our memories we'll retain our memories, and the reality is just that we don't as time passes. So having all of this written down can really be helpful down the road. And the other thing you want to do is, if there are documents like emails or photographs or something like that that demonstrate that harassment is happening to you, you also want to keep those in a safe space, maybe at home. Now finally, if you're unable to resolve harassment yourself in your workplace, then it may be time to report it, as many of you talked about. And when we report, we want to try to do that as much as possible in line with whatever procedure our employer has laid out in the workplace for us. And there may be lots of reasons that employees don't want to complain at work, don't want to talk to a supervisor, don't want to talk to HR, don't want to make a complaint to a higher up. And that's okay. So we all need to make decisions for ourselves about what our best course of action is in our workplace. That said, let's talk about the role of complaining. Workplace harassment laws really encourage prevention of harassment and resolution or stopping harassment by employers. The law would like employers to take action to resolve these issues before there's a legal action. So this means that there is a responsibility that the law does place on employees to report sexual harassment to their employers. And this is intended to give the employer the opportunity to investigate and to resolve that harassment without legal action occurring. Now, there are many ways to complain, as we heard during the question that we answered a few minutes ago. Employer complaint procedures are often going to instruct employees to complain to human resources, to a diversity office, to a personnel office. They may also instruct employees to report harassment to their direct supervisor. It's important to know that if the supervisor or if any of those people are part of the problem, we can go over their heads and we can complain to our boss's boss. Now, there really are very few requirements for what a complaint should include. Again, we want to always try to follow the employer's procedure. And we want to be very clear that we're complaining about harassment and that it's happening because of sex or our gender or gender identity or gender expression. And complaints don't always have to be in writing. We can make verbal complaints, but it is a really good idea to follow up on those complaints in writing so that we have a record in the future of our complaint. And once you report or complain, the responsibility then shifts to your employer to take action to stop the harassment and to keep it from happening again. So we'd like to review a few examples of complaints and talk about maybe what is good about them and what could be a little bit better about some of these statements as complaints. Michael, would you like to read the first one for us?
Sure. So this is an unclear complaint. And this person says, my supervisor is being very nasty to me lately. She has been abusing me. I shouldn't have to deal with her attitude.
Okay. So here we have a complaint. We can tell from this complaint that the complaint is about a supervisor and a supervisor that's engaging in some abusive behavior. But what we don't hear is, well, what are the behaviors? So saying someone's being nasty, someone is abusing me, that in fact may not be clear enough to tell your employer that what you are complaining about is illegal harassment. So if we can use the words harassment or discrimination, it's going to make our complaint that much clearer. Okay? The other thing that's missing from here is putting the employer, giving them notice about, what is this about, right? So if we're talking about harassment because of our gender, gender identity, gender expression, if we can say that, again, the clearer that complaint is going to be, the easier it's going to be for our employer to take action, and the more we will have protected our legal rights down the road. We have a second example of an unclear complaint. Michael, would you like to read that for us as well?
Sure. So the second unclear complaint says, some coworkers keep bugging me and getting in my way while I'm working. They're whispering about me. I wish they would stop.
Yeah, thank you. So here again, we have a complaint. It identifies who some of the perpetrators are. So it's some coworkers. But this complaint is lacking, again, in some of the same ways the first one was. We don't really know what the behaviors are that are being reported, and we don't know why they're happening. We don't see anything here about gender identity. We don't see anything about harassment or discrimination. And more importantly, I sort of see the things that this complaint is talking about here on this slide as, as not even really rising to the level of necessarily inappropriate or wrong behavior in a workplace. And that's partly because the complaint is not clear. So your coworkers are bugging you, they're whispering about you, that's not illegal. If they're doing those things because of your gender identity and that's interfering with your ability to do your job, then that may be illegal. So we want to make that complaint a little clearer. So we have some examples of some better complaints. Michael, would you like to read that first one?
You bet. So this first more effective complaint says, my supervisor refused to talk to me for 2 weeks and is making nasty comments about trans people when I'm around. This is sexual harassment, and I'd like you to investigate. Yeah.
Thanks, Michael. So that is a much clearer complaint. We know what the supervisor is doing. The supervisor's not talking to the person. The supervisor is making nasty comments. They're making comments about trans people. And we're saying, I think this is harassment, and I need you to do something. That's a much more effective complaint than our first two examples. Michael, could you read our last example for us as well?
Sure. So this last effective complaint says, coworkers are following me in the restroom and hanging around and staring at me. Someone threw a tampon. This is because of my gender, and I need you to do something. Shelley?
Great. Great, thanks, Michael. So again, this complaint is a bit more clear than the first two we looked at. And even though this person is not using the word harassment or discrimination, I think they're making very clear that they are experiencing abuse in the workplace because of their gender. They're clearly asking their employer to take some action, and that is enough to shift that responsibility to your employer for them to investigate and to stop that harassment. Okay? Now, there are some times when the law make some exceptions for making a complaint to your employer. And one is when an employee has a good and a fact-based reason for believing that a complaint to the employer will result in retaliation, right? When that's the case, we may be relieved of our duty to complain to our employer. Similarly, if an employer doesn't have policies, they don't have rules in place, if they don't have a complaint or an investigation process that's been communicated to employees don't know how to complain, again, we generally are not going to be required to have complained to our employer first before we take legal action. Now again, when we're making these complaints in the workplace, we should think about who can support us, who can assist us in a complaint process. And here are some examples of people in your workplace that could fill that role. So a coworker who is your friend or who you trust. It could even be a supervisor or a manager who is supportive. If you're represented by a union, you should have a union representative who can help you. If you're at a large employer, you may have an ERG or an employee resource group for LGBTQ plus employees, and somebody in that group might be able to help you. And again, if you have a lawyer or a legal representative, there's somebody who can support you as well. So we'll talk about now what we can do if our complaints in the workplace don't resolve our situation, okay? Or if we're unable to complain. The next step then would be to take legal action. And one note I'd like to just pause here for a second and offer is that we should all be aware that federal anti-discrimination laws protect all employees regardless of their citizenship or their work authorization status, but it is probably a good idea for an employee who does not have work authorization to seek specific legal advice about their situation before they take legal action. Now, there are a number of sources of assistance and legal assistance for you. If you're thinking that you need to take legal action about harassment in your workplace. And the first resource for you is Forge. Advocates at Forge are familiar with sexual harassment laws and legal processes, and advocates can speak with you about helping you understand your rights, offering advice for how to respond to harassment, and we can provide referrals to trans knowledgeable attorneys. Similarly, the Time's Up Legal Defense Fund that Michael mentioned at the beginning of the presentation and who has provided funding for today's presentation is also a resource able to assist trans and non-binary workers who are experiencing workplace sexual harassment. Time's Up can provide referrals to knowledgeable attorneys, and in some cases, they may be able to even provide free legal representation in sexual harassment cases. And we'll tell you how to contact Time's Up before we finish today. The third place to get help is free or low-cost legal services in your local area. There may be services available, and they may be dependent on income, but it's good to check that out. There is a website we've listed here, and this is on our resource sheets that you can download. That website, statebarassociations.org, provides information about local free and low-cost services. It provides information about your local bar associations or associations of local attorneys. And it also provides information about lawyer referral services in your area. So often that's a phone number you can call or a website that you can go to that will tell you who the lawyers are in your area who practice employment discrimination, for example. Now, the EEOC, or equivalent state or local agencies, is also a place to go for legal help. Employees who want to take legal action are required to start by filing a complaint with the appropriate federal agency, so that would be the EEOC, or the state or local agency in your area. And that has to be done before a lawsuit can be filed. Depending on what state you live in, that deadline can be 180 days, which is about 6 months, or it can be 300 days, and that's about 10 months. And we'll give you a link at the end to the EEOC website for their local offices. And those local offices, the local office where you live, should be able to tell you whether there are state or local laws that can help you and what your filing deadlines will be. Okay? Finally, I just want to take a minute to talk about law enforcement and reporting to law enforcement. We know that physical and sexual assaults can occur in the workplace. And a physical or a sexual assault is a crime, even when it happens at work. Employees who experience assaults at work should consider reporting the crime to local law enforcement as well. Now, we know that many trans and non-binary people might not feel comfortable or safe working with local law enforcement. We know that there have been rocky relationships between trans communities and law enforcement, and sometimes those relationships have been violent. And we know that there are trans and non-binary people who continue to have negative experiences when working with the police. And again, in 2015, the trans survey found that 20% of trans and non-binary people who were interacting with the police were verbally harassed. And 4% of them experienced a physical attack, and 3% were sexually assaulted. So because of this, trans and non-binary individuals might think about seeking support in working with the police. You might think about seeking support from an advocate, again, from a trusted friend or a coworker or a lawyer. And one important thing to be aware of is that in many states, someone who has experienced sexual assault has the legal right to have an advocate with them at all times when they're working with the police, and even when they're going to the hospital for an examination or for treatment. And we'll give you a website. There's a website listed on our resource sheet that'll tell you how to find out whether those laws are present in your state. So very quickly, we know that we have service providers and other professionals on the webinar with us today, and we want to just give you a few suggestions about the role that you can play in supporting trans and non-binary workers who are experiencing sexual harassment. So first of all, participating in webinars like this and being familiar with sexual harassment law and how it protects trans and non-binary people in particular is really important. Knowing how and where trans people can access local legal help and other support, maintaining a resource directory of trans knowledgeable professionals in your area, legal professionals, behavioral health professionals like therapists or counselors, or even sexual assault advocates who can provide support for someone who's experienced sexual harassment. Assisting trans folks in accessing legal help. And that could include even accompanying somebody and taking them to an appointment with a lawyer or advocating for them. Offering emotional support can be really important. Experiencing sexual harassment at work can be a traumatic event for people. And the other thing we can do as advocates is really pay attention to what's going on with the laws at a local and state level in particular, and participate in reform efforts and policy work to expand and increase legal protections for trans and non-binary workers. So with that, I'm going to turn things over to Michael, who's going to talk a bit about some resources we have to share with you, and then I think we'll move to wrapping up.
Thanks, Shelley. As you all heard, Shelley has an incredible amount of information that was shared today. And just to shift paces a little bit, I'm going to share some resources. And while I do that, I want to encourage folks to consider what questions you might have for Shelley and add your questions to that question box that Laurie will collect and then share with Shelley for us to talk about at the end. So let me share with you a few resources. Shelley's talked about many of them, and these will give you some links to those resources. So the first one that we'd like to share with you is the Time's Up Legal Defense Fund. So again, they're who funded this webinar and some of the resources that we've created, but they're also a place that offers some free legal assistance in addition to some paid legal assistance depending on if they take on cases or not. You can contact them directly at nwlc.org, or you can contact Forge and we'll help get you connected to them. Second resource is Forge. So we encourage you to contact us if you've had experiences of workplace harassment or sexual harassment at work. We would be more than happy to connect you with trans-knowledgeable attorneys or be that emotional support or some of that practical support for you. Shelley mentioned the Equal Employment Opportunity Commission many times today, and there are 3 links that are on this slide right now. EEOC has kind of lots of jurisdiction's probably not the right word, but lots of things on their website and lots of things that they oversee. So the things that are on the slide right now are a link to look at EEOC's comments on bathroom and facility access. The next one on the slide is to look at where you can file a complaint and how the instructions work so that you can have some guidance on filing that complaint. And then the third one, which is what Shelley just referred to a few moments ago, is where to find your local field offices. So that's the state level information. So those are 3 links that are really important if you're considering filing a complaint. The next resource is the Movement Advancement Project. And if you don't know about the Movement Advancement Project in general, they are just fantastic and their website is worth checking out. Their staff have compiled a lot of really useful documents and many maps like the one that we're sharing with you on this screen. It details which local non-discrimination ordinances are where in the country in terms of state and local that include gender identity. So at this time, when we're recording today in September of 2019, there are 21 states, including District of Columbia, that have non-discrimination laws statewide. And they're also showing on that map some of the protections for gender identity and expression that are in the local cities or counties. One of the things that we wanted to share with you as another resource is the State Bar Association. And this is an excellent source for locating directories of free legal services, where the bar associations are, and some lawyer referral services. So it's done by state, and you can look at what's appropriate for you where you are in your state. The next resource is the National Center for Lesbian Rights, and I'd encourage you to not let their name fool you. They have, from their beginning, cared very deeply about trans and non-binary people and trans and non-binary rights. They've done some excellent work for the trans community over the years. On their website, you can find legal information and resources and advocacy for trans and non-binary individuals, including a legal information helpline. Next resource is the Transgender Law Center. Many of us in the trans community know about the Transgender Law Center, and they can provide legal information through their legal information helpline. And these are for general questions about employment law and trans and non-binary employees. Note that they aren't able to provide legal advice about specific situations through their helpline. The next couple of resources are Forge resources, and these are ones that you can download right now through the handouts pod. So we created 2 fact sheets. One is a pretty general one that talks about a lot of the information that was shared today, called Frequently Asked Questions about Sexual Harassment of Transgender and Non-Binary Employees in the Workplace. And the second one is about retaliation. So we encourage you to download those either from the pod right now or from our website later. The other resource that Shelley's mentioned a couple times is a resource sheet that we created specifically to go with this webinar that has many of these links on it, as well as several more links. So we encourage you to download that either, again, from the pod that's marked handouts or from our website. one of the things that we're really excited about is that we'll be launching a social media toolkit that specifically focuses on sexual harassment. It's intended mostly for victim service agencies, so they can have some free and easy kind of social media posts that they can grab and post themselves, but we encourage anybody to use it and share information about sexual harassment in the workplace that affects trans folks. So as we move into questions, Laurie's going to be gathering the questions that you've asked already in the question box, but we encourage you to post your question there, and Laurie's going to speak and share those questions so that Shelley can answer in the last few minutes that we have today.
Thank you. Laurie goes ahead and speaks. We have a question that I'm going to paraphrase a little bit. Someone is having trouble with a coworker who says it's their religious right to not use the appropriate pronoun, that it would violate their religious rights to use the appropriate pronoun. Do you have any advice in a situation like that?
Yeah, thank you, Laurie. This is Shelley again. Thank you for that question. We've heard a lot more about individuals in this argument that folks whose religious beliefs are not, shall we say, supportive of LGBTQ plus identified individuals. We're hearing a lot more of this argument that folks have the right to rely on their religious beliefs in a way that means that they are potentially discriminating against or harassing, trans or gay and lesbian individuals. Now, there are a lot of different forums that this is happening in. We have states that are trying to pass laws to make that the law. So let me just say this. What this coworker is suggesting, so this idea that somebody's religious beliefs allow them to not treat us the way that we want to be treated, to not use our pronouns, to not use our chosen names, that is not accurate, okay? We don't have, I want to be careful here. What I want to say, first of all, is that our federal law, Title VII that we were just talking about, Title VII does not recognize this kind of right, this kind of religious right, essentially, to discriminate. What Title VII does do, and what our federal anti-discrimination laws do, is they protect the religious practices of individuals from interference by other people. But what we're talking about there is something much more like, my faith and my local practitioners meet, and we have services on Saturday afternoons. So, I need my employer to let me have Saturday afternoon off. Right? That's what these religious freedom statutes and laws, really have done for years and years and years. They've shielded folks from experiencing discrimination or harassment because of their religious beliefs. They do not take that shield and turn it into a sword, so an affirmative tool for treating other people differently. So our federal laws don't allow for that. And I'm gonna hesitate a little to say that when I talk about state laws, because I'm not familiar with the ins and outs of all states' employment laws. Some states have tried to pass laws like this, Religious Freedom Restoration Acts, and they've tried to pass laws that will give people these rights. I believe Mississippi passed one, and I think it's still being challenged in court. And I don't know that there are any others, but I could be wrong about that. So what's really important for all of us to understand, first of all, is that there's no legal right that gives people the right to turn their religious beliefs into a sword to discriminate against other people. So what I would probably recommend in this situation, and certainly I suggested during the presentation that trying to talk through and work out an issue with with somebody who is harassing you can be important. I think in this situation, my sense is it may be very difficult for you to dissuade this person or to convince this person that they don't in fact have this legal right. And this might be a time where it's useful to get some intervention from somebody in your workplace. Whether you do that informally with, again, a coworker, or whether you take that to your supervisor, or whether you maybe just take it to HR and say, you know, can you sit down and facilitate a conversation with me and this person? Or, you know, if you don't want to be present and be part of that, you don't have to. And you can talk to your HR and ask them to do something about this. And if you want, I think you can also file a complaint. You can make a kind of more formal complaint or report to your employer, because nobody has the right to refuse to use your pronouns, your correct name, to keep you out of an appropriate restroom, all the things that were on the list that we talked about earlier. So I would consider seeking some intervention at work to get some help talking to this person and helping them understand what your rights are.
Thank you, Shelley. I do have one other so far. Could you talk a little about intent to harass or discriminate versus unintentional harassment and discrimination?
Mm-hmm. Yeah, so that's another good question, and in intent, the intent of the person who is acting out is sometimes relevant. It's sometimes relevant in discrimination cases. It is not relevant in harassment cases. So I'm going to repeat that. Somebody's intent, whether they intend to be harmful, whether they intend to be discriminating, can be relevant in discrimination cases, but it's not relevant in harassment cases, okay? So it doesn't matter if you're being harassed and you make a complaint and your employer investigates and the harasser says, well, geez, I didn't mean to do that. You know, it wasn't my intent to be discriminatory or to be harassing somebody. It doesn't matter. The law is not concerned about what that person's intent is. The law is concerned about what is your experience as an employee. Is your environment safe? Is it free from discrimination and harassment? Or is it hostile and abusive? And again, it just does not matter what that person intends with their behavior. What matters is the kind of environment that you're working in and the terms and conditions of your employment.
Thanks, Shelley. This is Michael again. I'm mindful of the time, and I'm so grateful that all of you have been here today and shared this time with us and asked some really good questions. I'm going to advance our slides a little bit and wrap us up today. But if you do have more questions, we really encourage you to make those comments in the evaluation that's going to be sent out, or feel free to email us directly with additional questions that you might have. We are more than happy to respond in writing or have a phone call with you and talk through some more of your questions to the best of our abilities. So at the end of today's webinar, when the webinar closes, you'll receive an evaluation, and we'd really, really love to hear your feedback. We care deeply about what works and what doesn't work and what was most important to you. So if you just take a few minutes, we'd really value that, and we shape our future trainings based on the feedback that we receive. And I wanted to close out today by thanking Shelley for the incredible amount of knowledge and information that was shared today. We are so grateful and fortunate to have Shelley on our team. And we really want to thank Time's Up Legal Defense Fund for their continued support of this work and really being aware of the impact on trans and non-binary people's lives. And of course, we want to thank all of you for being here and taking time out of your weekend to be with us and for caring about these issues, whether you're trans or non-binary yourself, or whether you're a service provider or a loved one. We know that your presence here today is increasing your knowledge, and that increases all of our knowledge and creates a better world for all of us to live in. So thank you, everybody, for being here, and have a great rest of your day. Thank you.